Hi, I'm Dr. Roger Cohen, and I'd like to talk with today about the right to privacy. This developing theme of the right to privacy has changed and developed over time, and this is what we're going to explore today. I welcome you here to this lecture. The right to privacy describes something most Americans take for granted. It's a bedrock of our constitutional guaranteed has given it to us, but here in its first and most important thing I want you to hold forward and close to you today is these words appear nowhere in our Constitution. A right to privacy. Not once. Not in the text, not in the amendments, not in the Bill of Rights. It is a new construct that we've developed. So yet over 50 years, the Supreme Court treated the right to privacy as one of the most fundamental constitutional rights that we possess. One that was governed decisions about contraception, abortion, sexual intimacy, marriage, and increasingly your phone and digital data, even on your phone. So today we want to trace that story. We want to look at it from its philosophical origins in 1689, through the constitutional birth in 1965, and then through its expansionism period, and then its partial dismantling in 2022. And what we are now living in is the digital frontier. So what does that mean for today? So 5 parts and one story of how a right that isn't named can simultaneously be everywhere and nowhere in American law. So here's our roadmap you see in front of us. These are 5 parts, 5 panels. Part 1 is where we look at where it came from, and then we'll end with the idea of the digital roadmap and digital privacy in the future. We have to start by asking this question. What is the right to be let alone? The most comprehensive of rights and the most valued by civilized men is what Justice Brandeis wrote, dissenting in the Olmsted versus the United States in 1828. That phrase, the right to be let alone, didn't originate with the Brandeis or on the Brandeis court. He coined it 30 years earlier as a young Boston lawyer. We'll come back to that 1890 article in part 1. But now notice that he's describing not a specific enumerated liberty, but an affirmative zone of personal sovereignty, a space where government simply does not belong. And scholars today divide that zone into 3 categories, all of which appear on this slide in front of seen on the screen, and all of which appear in different forms throughout our cases that we'll look at today. There is the first, which is decisional privacy. The 3 cards at the bottom cover this idea to make it about personal choices without state intervention. So things like who would you marry, whether you use contraception, whether you continue a pregnancy, what you do in the privacy of your bedroom with a consenting adult. This is the category that generated Griswold, Roe, Lawrence, Obergefell, and it's the most politically contested. Then there's informational privacy, which covers personal data, who collects it, who can share it, what they can do with it, your medical records, your search history, your location data, your DNA. This is the category that underlies all HIPAA and GDPR, and every debate about surveillance capitalism that happens within the political sphere. Spatial and bodily privacy is the oldest and most legally settled form, the box on the right, the protection of the home, the body, the physical spaces from government intrusion without a warrant. This is grounded most directly in the 4th Amendment and has the longest historical pedigree. I want you to keep these 3 categories in mind because the courts have been most comfortable protecting spatial privacy, more uncomfortable with informational privacy, and most politically conflicted about decisional privacy. And that pattern will explain a great deal of what follows. So we have on here 4 great thinkers whose ideas gave the courts intellectual permission to protect something the Constitution never named. Locke, which is in the top left block, 2 treaties of government. Locke's argument is foundational. He said individuals possess natural rights to liberty, life, property that exists before any government is formed. Government doesn't grant these rights. It recognizes them and is constrained by them. This matters for privacy because it establishes the idea that there is a sphere of individual existence the state cannot enter without legitimate justification. Locke's framework is the seed from which the entire tradition grows. Top right is John Stuart Mill, On Liberty in 1859. Mill sharpened Locke's intuition into what he called the harm principle. The only legitimate reason for society to coerce an individual is to prevent harm to others. What you do that affects only yourself is simply none of the law's business. This is a philosophical core of decisional privacy, the conviction that intimate personal choices belong to you, not the state. When the Supreme Court in 2003 struck down Texas sodomy laws, it was reasoning with Mill that would have recognized immediately in those court decisions. The bottom is the Warren and Brandeis opinions. And this is the one I most want you to remember. In 1890, Samuel Warren and Louis Brandeis published The Right to Privacy in the Harvard Review. It's one of the most cited and most influential law review articles in American legal history. Warren was reportedly angered by Boston newspaper gossip about his wife's social life. The argument they made was far larger than that. They claimed the existing common law principles already implicitly protected something they called the right to be let alone, a right to personal dignity, to control one's own narrative, to be free from unwanted exposure. They were asking courts to recognize this as a distinct, legally enforceable right, where courts were slow to accept it, but the seed was planted. On the bottom right is Alan Weston's view, and this privacy and freedom of 1967. Westin gave us a modern vocabulary. He defined privacy as the individual's claim to determine how, when, and what extent information about themselves is communicated to others. He identified 4 states of privacy: solitude, intimacy, autonomy, and reserve. His framework is still cited in data privacy debates today, 60 years later. And when courts and legislators ask whether you have a reasonable expectation of privacy in your location data or your genome sequence, they're asking Westinian questions of privacy. So this takes us to the constitutional grounding. So privacy is not mentioned in the Constitution. It's in the numerous. That is a central constitutional problem. If you look at the text, if you look at the Bill of Rights, you will not find a word on privacy. It's not in the drafting, and it's not a drafting oversight of the courts. It's not something that the courts even corrected. It's the fact that it has generated genuine, ongoing interpretative crisis over the law. So how do courts justify protecting it? They use 6 different constitutional anchors, all of which you see on the slide. They use the First Amendment, freedom of thought, belief, association. If the government can't punish you for your political opinions or your religious beliefs, it's because there's a protected inner life that belongs to you. That implies a zone of privacy. The Third Amendment, the most obscure in the Bill of Rights, almost never litigated on its own. No quartering of soldiers in your home without consent. Its very existence implies that the home is a sanctuary from governmental intrusion. That principle matters. The Fourth Amendment, the most direct textual anchor for privacy, the protection against unreasonable search and seizures, warrant requirements, protection of your house, your papers, your effects. This is a spatial privacy written into the constitutional text and the foundation of everything we'll discuss about digital surveillance. The Fifth Amendment, the privilege against self-incrimination. You can't be compelled to testify against yourself. This is a form of informational privacy. The state cannot extract your own words and use them to destroy you. The Ninth Amendment, and this is where it gets philosophically interesting, the enumeration of the Constitution of certain rights can't and shall not be construed to deny or disparage others retained by the people. In other words, it's not an exhaustive list. People have rights that aren't written there. Justice Goldberg's concurrence in Griswold relied on this directly. The 14th Amendment is the Due Process Clause, and this became the primary modern vehicle for the right to privacy. States may not deprive persons of life, liberty, or property without due process. And the courts have interpreted that the word liberty to include not just freedom from physical imprisonment, but substantive personal choices, what lawyers call substantive due process. This is the theory that supported Griswold, Roe, Lawrence, and Obergefell, and it's also the theory that Dobbs partially dismantled. So here's the interpretive question that runs through everything. Is it legitimate for courts to protect rights not explicitly written in the Constitution? The answer to that question, which divides originalists from living constitutionalists, determines the fate of every right that we're discussing today. So right now, we need to look at the idea of the Griswold versus Connecticut case in 1965. If you look at the case facts on the left slide, Connecticut had an 1879 law, still in the books in 1965, making it a crime to use contraceptives, not to just sell them, to use them. So Estelle Griswold, the executive director of Planned Parenthood League of Connecticut, deliberately opened a birth control clinic in New Haven to get arrested and challenge the law. She was convicted and fined $100. The case went to the Supreme Court. The issue, as you see it framed in the slide, does the Constitution protect marital privacy in contraceptive decisions? The court answered yes. It's 7-2. Justice Douglas wrote the majority opinion. He faced a real problem. The Constitution says nothing about contraception, nothing about privacy in marriage. His solution was the famous numerous emanations theory. He argued that specific guarantees of the Bill of Rights, the First, Third, Fourth, Fifth, and Ninth Amendments, cast shadows that protect more than just their literal text. Together, they create zones of privacy that the state may not invade. The marital bedroom, he said, was one of those protected zones. So if we look at the bottom right column, the first two bullets describe two concurrences that are more doctrinally important than the majority opinion. Justice Harlan grounded the right to privacy in the 14th Amendment's Due Process Clause, arguing that liberty includes the right to be free from substantial arbitrary obligations. No need for numerous, just the word liberty. This became the approach adopted in later cases. It was much cleaner, more textually anchored, and more durable. Justice Goldberg relied on the Ninth Amendment itself, arguing that unenumerated rights are real rights, and the right to marry privacy is one of them. The last two bullets on the right take us forward. Griswold's significance extended far beyond Connecticut's contraceptive ban. It established that there are constitutional rights not explicit in the text, that they cluster around more intimate personal decisions, and that the government bears a heavy burden to justify intrusions into these zones. 7 years later, in Eisenblatt versus Baird, the court extended Griswold to unmarried individuals. Justice Brennan wrote the line that became the foundation of Roe. If the right of privacy means anything, it is the right of the individual, married or single, to be free from unwarranted government intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. So the right to privacy, Brennan said, belonged to the individual, not the couple, not to the marriage. That shift will matter enormously in the Roe versus Wade decisions that come up. So Roe v. Wade came on the scene, and in 1973, Justice Harry Blackmun wrote for a 7-2 court, the court holding tracks directly from where we left off with Eisenstadt, the right to privacy, recognized in Griswold and extended was broad enough to encompass a woman's decision whether to terminate a pregnancy. That right is grounded in the liberty of the 14th Amendment Due Process Clause, but, and this is crucial, it's not an absolute right. If you look at the following three bullets to the left, Blackmun devised the trimester framework. And the first trimester, the decision is entirely the woman's. The state has no basis to intervene. In the second trimester, the state may regulate abortion, but only to protect maternal health. And in the third trimester, once the fetus reaches viability, the point at which it can survive outside the womb, the state's interest in potential life becomes compelling. The state may restrict or prohibit abortion except where necessary to prevent the woman's life or health. Now that we look at the fifth bullet, Roe is grounded in privacy, not equality. This is something scholars argued about from the start. Critics from the left, including Ruth Bader Ginsburg, argued that grounding abortion in privacy was analytically fragile and politically unstable. A better theory Ginsburg offered would have been equal protection. Abortion restrictions burden women's equal citizenship in ways that have no parallel for men. So the privacy framework meant the right could be analyzed entirely in terms of the fetus interest versus the woman's bodily autonomy without ever addressing the fundamental question of equality. Ginsburg turned out to be right. So then we look at what happened with Planned Parenthood versus Casey in 1992. It's the three justices, O'Connor, Kennedy, and Souter, produced a remarkable joint opinion. They acknowledged Roe had been controversial. They acknowledged that they might have decided it differently, but they argued that stare decisis, the doctrine that followed precedent, required them to hold Roe's core holding. To overrule it, they would say, would make the court look like it was yielding to political pressure. But they replaced the third trimester framework with the second Casey bullet with the undue burden standard, where a state law regulating pre-viability abortion is unconstitutional only if its purpose or effect is place substantial obstacle to the path of a woman seeking abortion. Casey weakened Roe, and it permitted much wider state regulations. This takes us to our next point of discussion. Liberty presumes an autonomy of self that includes freedom of thought, belief, expression, and certain intimate conduct. That's what Justice Kennedy, writing for the majority in Lawrence versus Texas in 2003. The arc on the slide runs 30 years, as you can see, from a deeply embarrassing 1986 decision to transformative 2015 ruling. It shows the court correcting itself on a fundamental question of constitutional dignity. Bowers versus Hardick in 1986, which is the card on the left. Michael Hardwick was found by a police officer in his own bedroom in Atlanta engaging in consensual sex with another adult man. He was charged with Georgia's sodomy laws. The Supreme Court in 5-4 upheld the statute. Justice White's majority opinion narrowly framed the question as to whether the Constitution confers a fundamental right upon homosexuals to engage in sodomy, and answered no. He explicitly declined to connect this case to Griswold or to the broader privacy tradition. Justice Blackmun's dissent called it a case about the right to be let alone, but the majority won. Bowers was a severe miscalculation, both legally and morally, and 17 years later, the court said so explicitly. By Lawrence versus Texas in 2003, which is the teal card in the center, John Lawrence and Tyrone Gardner were arrested in Lawrence's apartment in Texas statute that, unlike Georgia's, applied only to same-sex couples. Justice Kennedy wrote a sweeping majority opinion that didn't borrow borrows. It overruled it entirely, and he wrote words that you see on the top of the slide, that liberty, he said, protects intimate conduct between consenting adults. The state cannot demean people's existence by making their private conduct a conduct of crime. Lawrence did something important beyond the immediate holding. It grounded privacy and liberty in the concept of personal dignity and personhood, not just a list of specific protected activities. That broader framing opened the door for marriage equality. That brings us to Oberfeld versus Hodges, the card on the right. Kennedy wrote for that court, the right to marry is a fundamental because it implicates personal autonomy, intimate association, and human dignity. States must license and recognize same-sex couples. Together, Lawrence and Oberfeld established that constitutional liberty covers the full spectrum of intimate life, regardless of sexual orientation. The Fourth Amendment in the digital age. So in parallel with the decisional privacy cases that we've been looking at and tracing, the Fourth Amendment was undergoing its own evolution, an evolution that is now accelerating in the ways the framers could never have anticipated. We look at the Katz test in 1967. Charles Katz was using a public phone booth to transmit gambling information across state lines. FBI agents had attached a listening device to the outside the booth, no physical trespass, warrant, no warrant, and the Supreme Court held this was an unconstitutional search. Justice Stewart wrote the famous line, "The Fourth Amendment protects people, not places." And Justice Harlan's concurrence created the two-part test. Did the person have a subjective expectation of privacy? And is that expectation one society recognizes as reasonable? That test still governs Fourth Amendment analysis to this day. But look at the two red cards. Miller and Smith. The court spent decades narrowing Katz through the third-party doctrine. If you voluntarily share information with a third party, your bank, your telephone company, you assume the risk and might disclose it to the government, that they might disclose it. So no reasonable expectation of privacy remains. In the analog world, this doctrine had limited practical reach, but in the digital world, where every action leaves a data trail with some third-party platform, it has become devastating to privacy. So in the teal card, we call the Kylo in 2001 ruling, marked the beginning of the court adapting to this change. So the police used a thermal imaging device at Danny Kylo's home and detected unusually high heat consistent with marijuana cultivation, no physical entry. The court held this is search. If technology allows the government to see in the home without physically entering it, a warrant will be required. In 2014, in Riley versus California, a unanimous court, Chief Justice Roberts writing, wrote, the police searched Riley's cell phone without a warrant after arresting him. They say a cell phone is not just another item in your pocket. It's a mini computer containing a comprehensive record of a person's life. The old common law rule permitting warrantless searches incident to arrest simply does not apply. Warrants are required. And then Carpenter versus the United States in 2018, which is the big teal card. The bottom, the government obtained months of Timothy Carpenter's historical cell site location from his wireless carrier and under evidentiary standard than a warrant. And Roberts, again, writing for a 5-justice majority, held that it violated the Fifth Amendment. Third-party doctrine cannot survive unchanged when technology enables near-perfect retrospective surveillance of every movement over a person's life. So that brings us to Dobbs versus Jackson. And June 24th, 2022, the Constitution Dobbs was fundamental, and it said the Constitution does not confer a right to abortion. Roe v. Wade had been, and Planned Parenthood versus Casey are overruled. That's it. 50 years of constitutional doctrine gone. The vote breakdowns of we see down at the bottom of the slide. 5 justices in the majority: Alito, Thomas, Gorsuch, Kavanaugh, and Barrett, and Chief Justice Roberts concurred only in judgment. And he would have upheld the Mississippi 15-week ban without overruling Roe entirely. And then 3 dissenters, Breyer, Sotomayor, and Kagan, in a joint opinion. The bottom bar tells you what's important about this historical significance. The most consequential privacy ruling in 50 years. You can debate whether that characterization is right, but there's no debate about the magnitude of the shift. 2 generations of Americans have grown up with abortion as a constitutional right, and Casey's plurality has struck the court's institutional credibility on preserving Roe. And here we are. We're having a shift in versus originalist versus an activist courts. So where does that leave us? It leaves us 3 different opinions which to look at. The left column is Alito's majority, and then Thomas's concurrence, and then the dissent. The majority explicitly limited its ruling, and then as you'll see from the 4th bullet, the reasoning applies to abortion specifically because abortion involves potential human life. It does not disturb other substantive due process rights. The center column was Thomas's concurrence. Thomas agreed with the majority but went further. Griswold, Lawrence, and Oberfell, he wrote, also lacked the support of the nation's history. And then, but Thomas's view is one of one justice, and the majority disclaimed it. And Thomas's argument is not frivolous, but it doesn't carry the weight of the full court stare decisis. And the right column, the joint dissent by Breyer, Sotomayor, and Kagan, they made 2 central arguments on the merits. Roe and Casey were correctly decided. The 14th Amendment's liberty has always been understood to protect personal autonomy, not the rights within a specific pedigree. But the majority's methodology is historically selective and constitutionally unjustified. So they believe the majority eliminated a fundamental right without adequate justification. So what happens post-Dobbs? So post-Dobbs, we will see different states having different levels of abortion applications, and new battlegrounds will arise. And I believe this is still a contentious issue for the future. So digital privacy, though. Where does it leave us now looking at digital privacy with the change? And there are, we have the stats listed here for call-outs across the top of the slide, and 4 facts are listed here. So there's no federal privacy law, zero. The United States has no comprehensive statute governing how companies collect, use, store, or sell personal data. 20 plus states with consumer privacy laws have laws. At the end of the card, you'll see on the lower left explains that they are enormously in scope, and they have different enforcement mechanisms, and the rights that they actually give individuals vary. California CCPA and CPRA are the strongest, and other states have some weaker laws. HIPAA from 1996 is the primary federal medical privacy law written before the laws of smartphones existed, and this also is looking at a problem. So why don't we have comprehensive laws? The American Data Privacy Protection Act of 2022 passed the House and Commerce Committee, but it died on the House floor because disagreement between California and the federal government over whether federal law could preempt California's stronger protections, and opposition from technology and advertising industries. So we've tried to, but it's been killed. And then if we look at the center card, the Genetic and Biometric Privacy, GNET, Act of 2008 protects you from genetic discrimination in employment and health insurance. It explicitly does not apply to life insurance, disability insurance, or law enforcement. So you see that there is an issue of developing out understanding of this digital privacy in a modern construct with older laws. The United States and the U.S. do have different surveillance concepts and also different ideas around privacy laws on how it's interacted. So there is an enduring tension in privacy. And as you can see, I've spelled this out very strongly for understanding privacy versus free speech from this enduring legacy. So where will we take away and where will we leave? We'll leave you with this idea here that privacy is inferred, not explicit. Dobbs overruled 50 years. The digital age has created a new privacy frontier. The U.S. lacks comprehensive federal data privacy laws, and the right to privacy is not a settled doctrine. I'd like to thank you for being in this lecture. Our time together.